Hey there, bar folks. I think Andrew is having some issues getting in with the link. So we're gonna keep working on that. Is it Jill or Errol tonight? I also don't see Joel here, so it looks like Joel does not have a presenter link. So we'll have to just put things on hold. Maybe I can drop something in the chat.
Can you send me, can we try to get in through yours? And I can just be you.
Yeah, we could try that.
Can you send me,
So go
what
to the link and put in my name, Anna.Conley at msu.umt.edu.
okay, just a second. Okay, Anna.Conley at what?
mso.umt.edu.
All right.
And then my password is just capital A August 16.
A
Let me log out really quick.
16.
Yeah, I better log out though.
Okay.
Okay.
Same issue I'm having. Did you log out?
Joel, are you there? Hi, everybody. We're still waiting for our panelists to join. We'll get started here in just a second.
Hi, folks. Finally got in. I'm sorry for the delay. Is there a, does AV host?
Andrew, Joel can't get in, so you have to introduce yourself.
Okay. It doesn't allow me to share my screen, which is a challenge. Is Errol able to allow me to share my screen? Hi, folks. Andrew King Reese here at the law school, and hoping to be talking about criminal law here in a minute. I apologize for the technical delays we've been having. And we're having one more technical delay or inability, which is I want to be able to share a PowerPoint with you, but it is not letting me do that. And I'm gonna hang up here.
Okay, if you want to email me the PowerPoint, I can log on as a presenter and share the screen.
I'm on as a presenter, but it won't let me share the screen.
Okay,
I don't know.
It should be accessible. All your permissions are on.
Well, when I say click on share, it says the host isn't allowing multiple presenters sharing for this webinar. I'm not sure what that. Maybe there's something else I should be doing here.
Go ahead and try again.
Oh, fantastic. Thank you. Okay. Okay, there we go. All right. Well, let's get rolling because we are a little delayed already, and I apologize for that. So tonight, what I'd like to do is talk about criminal law, sort of generally. It was billed as not what you see on TV, and we're going to talk about sort of three different areas: foundational concepts, safeguards or constitutional limitations, and then areas of concern. So if you have questions, I believe the questions are going to be available in the Q&A portion. And so feel free to throw questions into the Q&A, and we'll be monitoring those and trying to feed those or get to those as we go along. We're going to generate hopefully a lot of questions tonight, and I look forward to any participation or questions you have, and we'll try to answer those. I will have a couple of times that we're going to specifically go to questions, and so we'll see, but unfortunately Joel is not on. He was going to moderate some of that, so we'll do the best we can. Again, I apologize for all of our challenges. All right, so.
And Andrew, I'm happy to moderate questions, and I welcome them too, so bring them on.
Cool. So if you can, and Anna, what we had said with Joel was questions that you think are just relevant right now, feel free to feed them in. I do have 3 times for questions. So either way. Oh, it looks like Joel's going to join us. Fantastic.
Great.
Okay, so we're going to talk about 4 foundational concepts: the role of the criminal justice system, who the players are, the sovereigns that we have in the state, and then the sources of their authority. Writ large, the role of the criminal justice system really is to protect society, maintain public order, and we can think about that lots of different ways. And it's also to promote the rule of law through a fair and just application, right? So the idea is that people who are charged with crimes have been appropriately charged, there's sufficient evidence to support the charge and that they are treated fairly and justly in the resolution of those charges that have been brought against them. Okay, so that's kind of the basic goal. The players, what we see are the police, their job obviously to respond and investigate suspected criminal activity. Then we have the prosecutors. Prosecutors represent the people, right? So the county attorney, they represent the people of the county, whether it's Gallatin County or Missoula County or Yellowstone County, whatever it is. They are the ones who are responsible for making charging decisions. And the decision made based on whatever the police investigate and send forward, the prosecutor is going to say, yes, there is a crime there, or we anticipate we can prove this crime, or no, we can't. The ethical obligation for prosecutors, because they don't represent individuals, they represent us writ large, right, as a group. Often people who are victims of crime will sometimes say, you know, the prosecutor is my attorney, and that is not accurate. The prosecutor represents the people of the state, the United States, the county, the city, and their ethical obligation is to do justice. So that can sometimes conflict with what a victim or a survivor or a person feels is the appropriate response. Defense attorneys have a different ethical obligation, and their ethical obligation is to represent the people who have been charged with crimes. Okay. Our judge, neutral arbiter, they then also, upon a finding of guilt or a guilty plea, they are also the sentencing entity. So they're the ones who are going to impose a sentence and decide. We are an indeterminate sentencing state, which means we have a broad range for judges to decide. Fact finders are going to be our judges or our jury, depending if it's a bench trial in front of a judge or a jury trial in front of 6, 12 jurors. And then another player here is corrections. And corrections is responsible for, once the person's been sentenced by the judge, corrections is going to either probation or parole, right? Depending on where the person is being sentenced to, the severity of their sentence. And really, we're often thinking about punishment versus rehabilitation in that context. Okay. A couple of things I just want to highlight. For these players, in red, you see where they are exercising their discretion, right? And discretion is given to them in these areas. The police, in deciding whether or not there's probable cause to arrest someone, particularized suspicion to stop someone for an investigation, prosecutors in their charging decisions, whether there's probable cause to go forward, judges, what the sentence should be, bail, those types of things are all discretionary decisions. And we'll come back to that issue, but that is potentially an area of concern that we'll get to later. Okay. All right. Let's talk about the sovereigns for a moment. In this, for all of us here in Montana, we're subject to 3 different sovereigns, potentially, right? So we are all citizens of the United States as well. If we're a citizen of the United States, then the feds are one of our sovereigns, and they have trial courts and appellate courts. The state also, and we see our trial courts, justice court, municipal court, district court, and then appellate court. We only have one appellate court, which is the Montana Supreme Court. It's not 100% true. District court can be an appellate court in some ways, but it's really a new trial court. And then we also have tribal courts in Montana. So we've got a number of tribal courts. They have both tribal court and appellate courts. Okay, the sources when we're talking about why the sovereigns or where their power comes with regard to criminal law specifically, then the feds, it's coming from the US Constitution. The feds can only do what the Constitution tells them they can do. So that's what we refer to as enumerated powers. And the federal government's legislative powers are enumerated in Article 1, Section 8. And there's a list. Feds can do these things. So when the feds want to have a federal criminal law, they have to have a jurisdictional hook connected to one of their enumerated powers. States, on the other hand, it is inherent in state sovereignty that states can pass or enact or enforce criminal law. And that comes from this inherent state sovereign notion of police power to regulate health, safety, and welfare of the citizens. That's also reflected in the Montana Constitution. Okay, so we have state sovereignty inherent for criminal law. For tribes, they have inherent sovereignty to the extent recognized by Congress, and tribes have limited abilities to prosecute non-natives in tribal court. There are situations where that's possible, but generally not possible. Okay. Any questions about any of the foundational concepts, Joel or Anna, anything you saw there coming in?
I don't see any questions in the Q&A right now.
Perfect. Okay. So feel free to throw them into Q&A if you have any questions at all. All right, we're going to keep moving, try and make up a little time. So we're going to move on to safeguards. And here, really what I want to think about is when those exercises of discretion, right? So those areas in investigation and charging and sentencing, and the way we're thinking about criminal justice, there are limitations on those players that are imposed on the police, on the prosecutors, on the judges. There are limits, and most of the time what we're talking about is those limits are coming from our constitutions, either the United States Constitution or the Montana Constitution. Okay, so for example, for police, when they are investigating suspected criminal activity, they are limited by the Fourth Amendment for the US Constitution. The almost exact same language from the Fourth Amendment is in Article 2, Section 11 of the Montana Constitution, and it's the right to be free from unreasonable searches and seizures. Okay, so your Fourth Amendment, and it's important to understand that your constitutional rights protect you from the government. So when we're talking about this, police are state agents. They work for the government, executive branch, and that means they have to comply with the Fourth Amendment. Federal cops, FBI, or state troopers, deputies, sheriffs on the state side, they're complying with Fourth Amendment, but also Article 2, Section 11. There's also the Fifth Amendment in the US Constitution, Article 2, Section 25 in the Montana Constitution. You have the right not to incriminate yourself, and you see that all the time. I plead the Fifth, right? I'm not going to talk to you. That right is in the US Constitution and the state Constitution. I just want to highlight that when we're talking about these two constitutional rights, it's important to understand for the Fourth Amendment, Article 2, Section 11, Fifth Amendment, Article 2, Section 25, those are tracking. The language of those are the same. They don't have to be applied the same. The federal Constitution, so the Fourth or Fifth Amendment, establishes the minimum constitutional protection that the state or the federal government is required to give you or to recognize. These are the limitations on them, safeguards that you have against the government. States are free to give more protection based upon their state constitution or state law, but they can't give less. So in Montana, we have seen the Montana Supreme Court say that Article 2, Section 25 is going to be read broader and give more protection to criminal defendants than the Fifth Amendment. That's totally fine. They are allowed to do that. What they can't do is give less protection than the Fifth Amendment would. All right, prosecutors have some other limitations on them. The US and Montana constitutions have the trial rights that are set out in the Sixth Amendment and in Article 2, Section 24 of the Montana Constitution. So there we're talking about you have the right to a jury trial. It's a public trial in front of people, your peers. You have the right to know what the charges are against you. You have the right to confront the state's witnesses. And basically what that means is the state's witnesses have to come into court, testify, and you have the right, or your attorney has the right, to cross-examine those people and challenge whatever they have to say. You also have the right as a criminal defendant, if you want to have witnesses come tell your side of the story, you can compel them to come in. You have the subpoena power. And you have the right to an attorney to assist in your defense. Okay. The Fifth Amendment is not only used in investigation, it's also a trial right. So that's why I've listed it twice. Some other limitations or safeguards is the burden of proof. The burden of proof in a criminal trial is beyond a reasonable doubt. That is the highest standard we have in the law. It is the most difficult burden to meet, right? Beyond a reasonable doubt. You can think about comparing it to a civil matter, which is by a preponderance of the evidence, which is just a little bit more likely than not, like 50.1% versus 49.9%, right? Just a little bit more, that's a preponderance of the evidence. Beyond a reasonable doubt is much higher than that, okay? And the reason for that is because think about what's at stake in the criminal law. What's at stake in the criminal law is life and liberty, right? The state has the power to take you from your friends and your family and your community and put you, for example, in Deer Lodge, right? So in order for that decision, right, that incredible power and that incredible infringement on people's liberty, right, the idea that we're going to lock you up. Montana is a potential death penalty state. The idea that the state could take your life, those decisions are so serious that we guarantee all those constitutional protections and we make the burden on the state and the state only to be beyond a reasonable doubt. All right. So that's another significant safeguard. Another significant safeguard is the presumption of innocence. And you see, well, you see a lot of books and novels and movies, beyond a reasonable doubt, presumption of innocence, or presumed innocent, right? That's the title of a thriller by Scott Turow. The presumption of innocence, every jury is instructed about the presumption of innocence. And it's important to understand the presumption of innocence means that the state and the state alone has to prove the defendant guilty beyond a reasonable doubt. And if they can't do it, that presumption doesn't go away. The presumption is there. In other words, you are not guilty, okay? Until, and you have to be presumed to be innocent until the state overcomes that presumption beyond a reasonable doubt. So the burden of proof and the presumption of innocence are connected. Not only that, because you have that Fifth Amendment right not to incriminate yourself, that means criminal defendants don't have to testify. And jurors are not supposed to draw any negative inference from the fact they don't testify. Doesn't always happen. That's a tricky one for a lot of people. Well, you got arrested, you're here, right? Police think you did something wrong, prosecutors charge you, you're sitting there at the defense table, right? We're all here, there, you must have done something wrong, all right? And that idea is contrary to the presumption of innocence, right? So when we think about that, that's a very important, and then, like I said, it wraps up the burden of proof, and some additional concepts there. It's important to remember when we talk about the burden of proof on the state and only on the state, the defense doesn't have any burden at all. Defense can not put on a single witness, right? And they could still say, they don't have to cross-examine any of the state's witnesses. And then they could say in closing argument, state didn't meet its burden. And they could be right. Presumption of innocence has been overcome and the defendant is then acquitted, okay? Again, we see the same thing. I just want to reiterate that these rights, the federal constitution sets the floor and the state is free to give more protection if they want to. They don't have to, but if they want to, they're free to do so under state law. Okay. Questions about any of the safeguards or limitations?
Professor King-Reese, you might touch on this on your next slide, but on the safeguards and limitations, what about if those safeguards and limitations are violated? What is a citizen's recourse?
Excellent question. Thank you, Joel. You have a couple different types of remedies or ways to approach it. In the criminal context, we're typically thinking about a violation or as having some impact on the prosecution. So, for example, if the police violate your Fourth Amendment right to be secure, and they have an unreasonable search and seizure. For example, they're supposed to have a warrant to come into your house. They don't have a warrant. They come in anyway. We've got a violation of the Fourth Amendment or Article 2, Section 11. The remedy for that violation could be, and most time for criminal defendants, what they're trying to do is suppress any evidence that the police found when they came into your house, right? So imagine they come into your house and they find, they grab your computer and they find child pornography on your computer. That's a violation, sexual abuse of children in the state or possession of child pornography in the federal system. If they violate your Fourth Amendment rights in obtaining that computer and finding those images, then that stuff would not be admissible in the trial. They would be suppressed. So that's one way we think about it impacting. Another way to think about that impacting is sometimes people can sue for damages for a violation of their constitutional rights. And that's what we call a 1983 action. And that isn't about trying to avoid the prosecution. That's more about trying to obtain damages or other relief for some constitutional violation. For example, we see that in more of a, say someone's incarcerated and the jail is not treating them appropriately, they could file a 1983 action saying that my constitutional right, say, for example, under the Eighth Amendment, cruel and unusual punishment is being violated, and you should either stop doing that or pay me. So those are some of the other ways you could think about it, is suppressing evidence or dismissing a case. And sometimes, for example, if the police stop you without any suspicion at all, that would be a violation of your Fourth Amendment right to be secure from an unreasonable seizure. And a court could say in that, you're right, police didn't have any grounds to stop you, and we will either suppress any evidence that they found or dismiss the charge against you. Is that
Thank
what you were getting at, Joel?
Yeah, I guess another thought I had too was just the malicious prosecution, approach in civil law as well. There's a remedy there too. But yes, those are the things I was thinking about: suppression and a 1983 claim.
Excellent. Excellent. Okay.
And I do see a question in the chat, Andrew.
Let's see here. Oh, the question is, who determines what is reasonable?
That's a great question. And I think if you are connecting that question to the standard we were talking about earlier, beyond a reasonable doubt, for example, or you have the right to be secure from an unreasonable search or seizure. So we'll take those separately. Beyond a reasonable doubt, that is a determination being made by the fact finder, the judge, if it's a bench trial, or the jury, if it's a jury trial. And it is a remarkable, it's a remarkable limitation on the power of the state. If you think about what it means to have a jury trial, you can also think about the same thing with a grand jury. But if you're thinking about what a jury does, a jury stands between the state, either the prosecution, right, and the criminal defendant. And basically what they're saying is, you have to convince members of your community that this person's conduct violates our community standards as expressed in the legislation. Okay, so that's pretty remarkable, really, because we just pull random people, right, average citizens, and we say, please come to court. We're going to pay you an enormous amount of money to take time off of work, to come down to the courthouse, to struggle with parking, right? All the challenges. And we're going to ask you to make this incredibly serious decision. As we talked about earlier, the stakes in the criminal law are people's life or liberty, right? So we're injecting this power, this safeguard, this limitation against the state. And we're asking that and putting that on average citizens to make those decisions. The jury is instructed that they have to determine beyond a reasonable doubt. The question becomes, what does that mean? And really, I think what it means is that a reasonable juror, the people in the jury, come to a decision and they believe that's a reasonable decision. That's kind of a circular answer to that question, and I appreciate that. I have yet to read a specific, numeric calculation of what it means to be beyond a reasonable doubt. I really think what it means is we're talking about whether or not members of this community view these things, views this conduct as being problematic. And so when they come to the jury, and I have incredible respect for the jury system, and when jurors come to a decision, then we recognize and validate that decision. So the other question was reasonable on the Fourth Amendment, for example, and that is going to be a determination by the judge, because that will be a pre-trial question. In other words, someone would say, hey, you violated my Fourth Amendment. You should suppress this evidence. There was an unreasonable search or seizure, and the court will look at the law and the judge will say, we agree or disagree with that. And that question is decided before it gets to the jury. Then the jury is deciding really whether or not the criminal statute's been violated.
Thank you. We have another question too. What is the 1983 Act or a 1983 claim?
What is the act? Or is that what you said?
Yeah, that's the question.
Okay, so it's a state, some state agent, so a government official, someone violated an individual's constitutional rights. And so the actor is the person who works for a government entity in some fashion, who has then is being alleged to have violated some citizens' constitutional rights.
All right. It
Okay.
doesn't look like we have any more questions here. Yep.
All right, cool. So we're just going to keep rolling and get into our areas of concern. Because what we've been talking about are ways to think about why we can say the system is valid and working the way it is intended to be working. In other words, we see that people in the system have their obligations and their limitations on them and their restrictions, and they have to comply with the law, comply with their constitution, the constitutional restrictions on them, right? So when police officers are doing their work, they are constrained by the constitutional rights we talked about. When the prosecutors are doing their work, they are constrained by all of the things we were just talking about. And again, the idea behind the system, the role of the criminal justice system is to protect public safety, to maintain public order, and to promote the rule of law by having a fair and just application of the criminal justice or the laws as written. Okay. But as we all know, even with all those areas, or even with all those protections, there are still areas of concern. We are all understand that there are things that are not perfect about our criminal justice system. And so let's cover some of those areas that we've seen. When I talked earlier about the exercise of discretion by the police, by the prosecutors, by judges, what we see are studies that show there are racial disparities at every stage. And what I mean by that is that people of color, racial minorities are overrepresented due to from their population. So if African Americans are 10% of the population, they are a much higher percentage of people who are stopped by the police, who are searched by the police, who are arrested, who are then held without bail, who get higher offers in their plea bargaining, right? Who are sentenced to greater sentences. So we see this racial disparity at every stage. In Montana, we have a Native American population that's somewhere between 6 and 10% of the population, and there's somewhere between 26 to 30% of the population in Deer Lodge. So those racial disparities we see, and some people have said that the exercise of discretion at every level, every time there's an opportunity for discretion, we see an increased disparity based upon race. Okay. that is obviously problematic when we're talking about a system that is supposed to be just and fair. Another area of concern, and we've seen a lot of discussion in the past 5 to 10 years, talking about mass incarceration or over incarceration. And that, I think, has come up specifically in some areas like the war on drugs. And people complain that the war on drugs was really an opportunity to lock up a lot of people, and that we were over incarcerating people in that area. There are lots of crimes where there isn't over incarceration, right? So we see a lot of areas like domestic violence or sexual assault where there isn't excessive prosecution or conviction, right? So that's a broad category. But if people are being over incarcerated, and by over incarcerated, if that means that the system is not treating people fairly, or not treating people fairly, then again, that's an area of concern. Another area of concern that we see is that the Sixth Amendment guarantees criminal defendants the right to an attorney. And I'll just say that pretty broadly. Okay, there are a couple of little exceptions to that, but by and large, if you can't afford an attorney to represent you in a criminal matter of any significance, the state will pay for it. We have a public defender system, and the state is required to provide you with a criminal defense attorney. Because, as we said, the stakes are so high, and it's just not fair to ask people to represent themselves, right? You're free to represent yourself, but it's just so, there's just so much at stake, right? So many people around the country and around the state say that we do not have sufficient numbers of criminal defense attorneys in the state. We do not have sufficient resources. They're not being paid sufficiently to make sure that people actually go into that area, and they don't have enough money for investigation and experts and things like that to adequately represent people. And most significantly, the caseloads are too high because of the other financial issues. So they don't have sufficient time to be able to adequately represent a criminal defendant, so that the Sixth Amendment is there on paper, but it's not exactly Article 2, Section 24, but that right isn't being realized in actuality. Another area where people express concern is that the state has too much power in plea bargaining, and that people will they'll plead guilty to get out of jail. Even when they are asserting their innocence, they'll say, yeah, but I need to get out of jail because I need to get back to work. I've lost my job, or I'm going to lose my house, right? And so the opportunity for the state to bargain, even when, so in other words, it's somewhat, the argument is, disconnected from the reality of the criminal conduct. Another area that we see is mental health and the intersection between mental health and the criminal justice system. We see a significant percentage of people in custody, particularly at Deer Lodge, who have serious mental health issues or challenges. And what we see is that the criminal justice system is the institution that is, by and large, where our society puts people who have serious mental health issues that commit crime, right? So when there's this intersection, is that the right institution? And that's a significant question. And then corrections priorities. What we're seeing is starting in the mid-90s, there was significant push to build prisons and punish people for criminal activity. And recently there's been questions of whether or not that actually is the best use of our money and the best use of our resources, and really does it promote or reduce recidivism rates. So we're seeing things like treatment courts, drug courts, veterans courts, domestic violence courts, where instead of locking people up, we're trying to provide them resources, services, where we can actually focus on rehabilitation. Okay. That I just threw out a lot of information right there about some of the areas of concern. And do we have any questions on those?
Yes, we do. We'll start with the first one, and it's pretty long, so I'm just going to quickly try and summarize the high points. But the attendee says, I have serious concerns about restraining orders not getting issued that should be, and I feel like the system is breaking down. And just, I think to summarize, it seems like this person says it feels like it's like pulling teeth anymore to get a TRO or a TOP.
Okay.
I don't know if you want to comment on that.
Sure. So that's I'm really glad you raised that question. I think that's an important question. The TRO or the TOP or the order of protection is actually a civil matter. And we have criminal sanctions potentially for violating one of those, but that is a matter that goes before the court, and you submit your petition, and the judge decides that, and then you have a hearing 20 days later. And as I said, that's really a civil matter, whether or not this person's going to stay away from this other person, stay 1,500 feet, right? Stay away from the kids, the house. Like, you can put all kinds of things in it in an order of protection. A no contact order is often issued by the prosecution. When someone's been charged with a crime, they'll say, okay, no contact means during the course of this prosecution, you cannot have contact with the victim, the witnesses, and things like that. All right, so no contact order is criminal. The restraining order is civil. And so the burden of proof for the restraining order is preponderance of the evidence. So much lower, as we talked about. And if someone violates that, and the police are called, you can be charged with violating an order of protection, and then it would be a criminal matter, and the burden of proof on that would be beyond a reasonable doubt. So I understand people's frustration there. I won't go in more of that. That's a family law question, and hopefully there's going to be some family law conversation at some point during the Citizens Law School.
We have another question, a couple of questions here. Why is there not enough funding or genuine support for public defenders?
That's a great question. So really, to me, that's a question of what can you do, right? So how do we respond to these concerns we just talked about? And it's important to understand that the majority of crime in the United States is state or local crime. There are federal crimes, no question, but the majority of stuff is at the state or local level. The legislature sets policy, they write the criminal statutes, and they control the budget. So we're seeing that these things are not set in stone, right? And they are changed. They go back and forth, right? So we've seen in recent times, we've seen legalization of marijuana, right? Where people felt like there was over-criminalization, that was not the drug that is the most dangerous or problematic for society. And now we see dispensaries all over the state. And that is a policy decision that was made by the legislature to say that this is no longer a crime. The feds have not made that same policy decision, right? Congress is still saying possession of marijuana, distribution at the federal level is a crime. Okay, state, we can make a different decision. Recognition of gay marriage, gay sex used to be a crime. And the United States Supreme Court recognized gay marriage. And with that, they also recognized the right to engage in homosexual sexual activity, right? Reproductive rights. Many states after Dobbs have now said abortion is illegal. And not only is it illegal, it's a crime. And it's a crime to help someone. It's a crime. Many places are saying doctors can be criminally prosecuted, people who assist, right? Investigation and interrogation procedures, we've seen massive shift in recent years where officers now are all wearing body cameras. They are required to record and keep the interactions with citizens. That came about because of advocacy saying police can do better and we need to have more restrictions or more control over the way they are conducting themselves. The best way to do that is let's record the interactions, right? And so what I'm trying to say is these questions, so why isn't there sufficient funding for public defenders? One, because public defenders cost money. And two, many people make the argument, well, you're guilty, so why do you need an attorney? That is problematic, in my opinion, because our system, all of those protections fall apart if we don't have both players, the prosecution and the defense, and the judges and the lawyer and the police all being held accountable in an adversarial system. And that system falls apart when the prosecution is not doing their job or when the defense is not doing their job. So those are, at bottom, really legislative policy and budgetary decisions.
Great. We've got another question. Do victims have a say in plea bargains in Montana, or can prosecutors offer agree to plea bargains without victim input?
That's a great question. So yes, victims have a say. They're supposed to have a say. It is a matter of law that they're supposed to be consulted. Again, so 2 points on that. One is it doesn't always happen, and that is not okay. Prosecutors should be contacting victims and survivors to say, here's the proposed plea deal. How do you feel about it? Okay. But again, remember what we said earlier, the prosecutor's job is to do justice and to represent the people. They are not the attorney for the victim. If they were the attorney for the victim, they would, if the victim said, I don't like the plea bargain, the prosecutor would not be able to go forward with that plea bargain because that would be their client. But they're not their client. The prosecutor represents the community, and so they are able to make the decision ultimately whether or not they think that plea bargain is in the interest of justice. But statutorily, they're supposed to consult with victims, and I've heard that before, that's not being done often enough or seriously enough.
One more question, Professor King-Reese.
Yeah.
Is there a concern about the role of private prisons in the over-incarceration question?
Or
Or
yes.
issue?
Yes, I think many people felt that starting in the late 80s, but really taking off in the 90s, that the rise of private prisons created, incentives to fill them. Because the private prison needs bodies. That's how they make their money. And we have seen situations, there was a classic scandal in Pennsylvania in the juvenile court setting where the juvenile court judges were sending kids to the private juvenile detention facility, and they were getting a kickback for every kid they sent there. And they were ultimately prosecuted. The judges were prosecuted, and that was really that economic model created an incentive to over incarcerate, right? And so, yes, I think that's a serious concern. I just heard yesterday that the legislature had, because we're really at capacity in Montana, in our prisons, Deer Lodge is full, really, I would say probably over capacity. And the legislature's decision was to fund sending 122 prisoners to Arizona and contracting with Arizona to incarcerate folks. And we're now, I guess, the Department of Corrections is over that amount and has increased the number. So that raises a different concern, because Montanans are now being held out of state, which makes it much harder for them on re-entry to think about, people are going to get out of prison. So they are separated from their communities and their friends and their family and their love and their support system. So it makes it's much harder on inmates when they are being shipped out of state. Again, those are legislative, budgetary, and policy decisions.
Great. It doesn't look like we have any more questions.
Okay, well, we made up some time, as the airline pilots always say. Well, we're not quite as late as we were going to be. So I hope that, I apologize again for the delays and appreciate your patience, and hope that was helpful or instructive. Feel free to email me if you have more questions later, but thank you so much. It's been a pleasure. Thanks, Joel, for all your help, and Anna for your help as well.
Thank you so much for doing this lecture tonight. And just a reminder to attendees tonight that next week we will be talking about property rights when the Citizens Law School continues. And on behalf of the Law Related Education Committee of the State Bar and the State Bar, I just want to thank everyone for attending tonight. So thank you. Thank you, Professor King-Reese.
Thank you.
All right. Have a good evening, everyone.